This is the future.
Thank you so much, ladies and gentlemen. After hearing Pawan, I think there's nothing else I have to speak on this topic anymore. And I think Dinesh is here as well. I thought what I would like to speak to you today is how the law is evolving, why this, you know, confusion that was created by introduction of the Personal Data Protection Bill in 2019, subsequently being withdrawn after about 2 years of consultation in the Joint Parliamentary Committee on Personal Data Protection Bill, in which I was a member, and subsequently introducing a new law. You see, the most important guidance for Government of India when they introduced the 2019 bill was the UGDPR. And this UGDPR formed the basis for the 2019 Personal Data Protection Bill. But before that, in the Puttaswamy case, both the cases, the Supreme Court itself used a lot of the EU GDPR as its guidance while writing the judgment. And therefore, B.N. Sri Krishna, when he framed the draft laws in 2018, brought in a lot from this, and subsequently the Government of India took again a lot from there, and that is why it almost became, as they say, cut and paste kind of a EU GDPR law. However, during the consultation of about 2 years, in which the current Minister IT was a member himself, as well as the Minister of State being a member. Both the Minister and this Minister of State were members, Rajiv Chandrasekhar and Ashwini Vaishnav. We used to, the witnesses who came from across the country, from educational institutions, universities, lawyers, legal law firms, the big tech companies, the social media intermediaries, I think, I don't remember the exact number of sittings, but I can tell you that we had 2,000 odd pages of depositions that one could go through. Now, during this entire process, the difficulty, the approach that was followed by the Joint Parliamentary Committee was to improvise on the EU GDPR to the extent possible, using the Indian context, and also after hearing the depositions from these, as we say, witnesses. But the Indian context was different to the extent that the current growth drivers of Indian economy is largely being woven around reviving, giving strength to the MSME sector. In the Act itself, in the PDP Act of 2019 and in the EU GDPR, there are no separate carve-outs for startups or for micro-small enterprises. Even though we thought of having a carve-out in the in the 2019 PDP bill to give protection to these people or give some kind of a transition, increased transition time to these people, the feeling, particularly at the level of Honorable Prime Minister, was that we cannot have hard regulation in place, just as probably the EU could do, considering the fact that our economy has to be driven by innovation from emerging technologies, which would be largely also done by small micro enterprises, maybe in MSME sector. So the decision was to shift away from the completely prescriptive EU GDPR model of the Act to a more principle-based current version of the Act and leave aside the prescriptions, detailed prescriptions to the rules. So what you are going to probably see in the rules would be a lot of the things which was there in the 2019 PDP bill and currently not featuring in the new bill. Having said so, I must also say that in the EU GDPR, the penalties were even more stringent because it was treated as a criminal offense. There was an offense chapter in the EU GDPR and in the PDP Bill 2019, which has now been completely removed and it is made into a civil law, and therefore the fines, the hefty fines, basically to the kind of thought that went behind having these hefty fines. In fact, if you look at my speech in the Parliament, I had probably pushed for even heftier fines for different kind of data breaches, because I thought, and which you may probably consider thinking, is that data breaches affecting women, children, and reputational loss has to be even more stringent. That is what I had spoken in the Parliament. But anyway, the thought that went behind this is that privacy by design need not necessarily come because of prescription in a particular law which was there in the PDP bill, but should come out of their own internal requirement. As Pawan was saying, otherwise you'll go to jail, otherwise you pay fines, and fines are very hefty, so you develop your own systems. We don't have to tell you that this is what the privacy by design would be. So the principles, in order to make the current act very simple and also ensure that there was no confusion between digital and non-digital personal data, because the previous bill was personal data protection, the current one is digital personal data protection. The Supreme Court's Puttaswamy judgment doesn't distinguish between digital and non-digital while dealing with privacy. And rightly so, because privacy, if it is compromised, arising out of a data which has been kept in a non-digital format is equal violation of the privacy of that particular person. So the current act says that if subsequently, even if that particular data which was maintained in a physical form, in a non-digital form, but if it is transferred anywhere at any stage into a digital form, will be covered under this act. So in a sense, it covers almost everything. I was just trying to take it forward from what Pawan was saying, of course, about the personal data protection bill, the history behind this. But the requirement or the necessity that was felt of not following the EU GDPR verbatim or in minor customizations to a completely new principle-based legislation, the thought was we or the country decided to err in the favor of innovation, probably at the cost of privacy, purely from the point of view that innovations at this point of time is what is going to take the Indian economy forward to $5 trillion or whatever. At a subsequent stage, maybe harder regulations would probably come in, maybe by amendment of the Act, but definitely not through the rules, because that would require significant changes in the provisions of the Act. But some of the basic principles relating to data minimization, relating to purpose limitation, relating to storage limitation, collection limitation, accountability, equality, which was there in the Puttaswamy judgment, has been maintained in this new law. The details which were there in the earlier law, however, has been left for the rules to be regulated because of one reason, that as we are evolving as an economy, as a digital economy, being one of the pillars of our entire $5 trillion or even subsequently $7 trillion in 2030 aspirations, we need to promote innovation, need to promote startup ecosystem, make it vitalize it more, and the MSME sector. This dilemma of which is the right balance between regulation and innovation is being faced by countries all over the world, by legislators all over the world, and by governments all over the world as to how much to take forward, how much of regulations they should bring in that would not stymie innovation. Which is the right balance would depend on in the context, and also at what point or at what point of time that particular regulation is being brought in. As we know, regulations would always lag innovation, will lag technologies. And this is what is already happening. If we, for each time one has to come to the parliament to amend the provisions, you can imagine the lag period would even become longer. And therefore, the decision to have only a principle-based system as in the personal data protection bill, the new one, and leave a lot of it to the rules which can be easily amended from time to time, keeping pace with the regulation, keeping pace with technology, and keeping pace with the emerging technology and applications. You would be surprised to know there are several applications in various spaces at a cross-section of various sectors which are still operating without any regulation by either the RBI or by the IRDA or by the SEBI or by any other regulator. Now, to provide regulation for each one of them through an act provision would be very difficult. And that is precisely the reason why this particular act looking very simple, but principles have been well laid out and in compliance with the Puttaswamy judgment. As Pawan was saying, that the act has not yet come into operation. The compliance of which would require a complete transformation or putting in a completely new structure right from the time a primary data is created till the time it is processed and finally used somewhere in a reporting format. And this is applicable even to government companies because any data fiduciary will have to do this. Whether it was, this is again one argument which probably you can argue on both sides, whether this should have been provided in the Act itself, providing different transition periods for different sectors could have been a better way, or doing it like a big bang on a particular date this Act comes into operation, or certain provisions of the Act comes into operation in different dates of time. Now, that's the third option. I think this is what has been prescribed in the new data law. But today, for example, while answering a question in the Parliament, the Honorable Minister IT, Mr. Ashwini Vaishnav, to a question on what is being done to protect citizens against data breaches, against privacy, harm caused out of a compromise of the privacy. You can see today itself it is there, I think question number 78. He has given a detailed explanation of what is being done, what is the awareness that is being created, and what the CERT-in has done. During one of the parliamentary depositions of certain officials, including the director and the IT officials in the Standing Committee on Finance, in which I'm a member, there's a question, and this is what I'm trying to lead it to. You have to start thinking on this. One side is compliance of the current legislation, current laws, One more which is left is the Digital India Act. There's another one which will come in the lines of the Digital Markets Act, which is in the Ministry of Corporate Affairs, or together with Services Act, Markets and Services, Goods and Services. But the point here is that during the deposition and also in the Act, it is provided that an incident has to be reported by a complainant. And the reporting period has been given. If the reporting is not done, does the certain have the ability and capacity to enforce the law by imposing this penalty on each and every such transgression of the law? To this question, I think this is the basic question. You must read into this. When the Rasmika Mandana case, that's the right name, is it? Yeah. Happened, the response of the ministry, the MOS said, that you follow the IPC, you go and file a case in the police station. Now, which police cyber cell in which particular state is so well has the capacity to prosecute, first to investigate, and then to apprehend, and then to prosecute. Now, this is just an example of how helpless the government would be. Even if there is a direction by the Data Protection Board which is going to come up to impose a damage which is easier to implement, criminal action would be required to be taken in certain cases, because if it falls foul of the IPC or the new laws, there is a problem. When there is a reputational loss to women or children, fines will not be adequate. Fines will not be sufficient. Criminal action has to be taken. Now, for criminal action to be taken, one, of course, there has to be a complainant, therefore reporting is in sync with this. But does certain have the capacity to regulate the internet? As the government says that we want to provide internet which is safe and trusted to every citizen of this country. Given the digital illiteracy or digital literacy levels in rural India, is it possible for them to report all such incidences and to impose a fine of 10,000 rupees if that particular complaint turns out to be frivolous? Therefore, my personal view is three things. The implementation of all these IT laws would be more efficacious only when the implementation of the laws is decentralized. Currently, it is a completely centralized model. This will work well probably at this stage of our economic growth or digital economy that is there, which is quite huge in the country, in the world, by comparison to any other country in the world. But it is going to grow and grow enormously. People who have bought something in a tier 3 city in a village will probably be affected because they have been cheated of a particular product which they have paid for and they have not been given that particular product. The current requirement of settling this through e-courts kind of a mechanism that has been prescribed in this, that is, you file it through this, I think will not work, number one. Number two, even if you decentralize to separate authorities at the state level or at the district level, just like the consumer courts. Consumer courts are at the district level. Consumer education, mediation is provided in the new Consumer Protection Act 2020. The Consumer Awareness Fund is created under the Act itself. None of this is there in the new law. Whereas this is the pressing requirement. Besides decentralization, a huge awareness campaign has to be made of all possible principles, data principles, and data fiduciaries. Anybody who was collecting a data of whatever magnitude is actually a potential data fiduciary, if it is using it to cause some harm to somebody. And therefore, the need for some kind of a fund is required. That I think this is what we had mentioned. I had mentioned during my arguments in the bill. Unfortunately, the entire opposition had walked out on that day, so therefore the discussion really couldn't take place on such a significant bill. Which I thought in independent India, it's one of the most significant legislations because it's affecting the privacy of every single Indian born and who will be born later. So this is the second point which I wanted to make, that reporting could not be the only criteria to move ahead. The certain has to be empowered, both in terms of manpower, as well as funds, as well as reach, to be able to put in place structures to at least monitor big cases of cyber attacks or data breaches. The current system of reporting is taken from the usual police case system in which there has to be a complainant to start the process. In case there is no complainant, then nothing is done, because where is the complainant? That's the question in the law, in the courts. But if something is affecting a community or a country or a particular state or a particular district to such an extent that it could jeopardize, and you can understand that many of these IT systems are so linked that it may jeopardize other systems who would be probably drawing from this data, could create unintended damages to people who are not really directly involved in this particular transaction. I will give you an example. This is the second point that we have to do. We have to build privacy by design, not only in IT systems. It has to be there in every act. The mere provision that this act will supersede any other provision, if it is contrary to that extent any other law for the time being enforced, would not be adequate. Give you the example. Every company is required to prepare a disaster recovery plan in case of a disaster and a business continuity plan. I have, again, through committee reports, I have seen that none of the Maharatna companies, none of them, I'm not coming to even mini Ratnas, none of the Maharatna, Navaratnas companies have cyber attack, cyber security as one of the disasters in the disaster management, because that was prepared in keeping only natural disasters in mind. But isn't that a threat? And linked to that particular threat, because your response will be linked to the response to a natural disaster could be in IT systems, which would be there anyway. A leakage or a breach can also happen at that particular point of time, from that particular place in the chain. Now, if that would actually get into the disaster recovery plans and business continuity plans of all companies and is made a prescription for everyone to follow, then I think a better efficacious implementation of the law would take place. Currently, it is basically giving protection to the citizen, who is a data principal, sharing data. But if you want the entire ecosystem to develop, I think this has to feature or be mainstreamed into every law that is being made. Let us say the Consumer Protection Act. It's all-inclusive, highly all-encompassing law. But the violation of consumer rights cannot be completely divorced from violation of the same consumer's privacy rights. But if you look at the Consumer Protection Act, you will not find reference to the word privacy anywhere, because two different departments are doing it at different points of time. Their objectives is different. But the platforms who are involved in supplying goods and services to the consumer, who is also a data principal, are the same. Therefore, a filing of a case by the data principal would be violation of section so and so of Consumer Protection Acts, raid with violation of this, as it happens now. Now, if you want to make your law efficacious, if you want to have a compensation mechanism for the data principals to get in case people breach the data or steal their data by whatever method, then it has to be made simple. And this is what is currently the next step that the government of India should be doing, in my view. The 3 points which I said: decentralize, educate, and third, build this into all other laws so that it improves the entire ecosystem of privacy in the country. Why this is important? Because emerging technologies use different data sets from completely different data principles, or data fiduciaries, I would say, and develop applications. And this is going to grow. I have people who are using, who are innovatively thinking of using data, let's say a composite insurance package for farmers is developed, in which they can get health insurance, they can get equipment insurance, they can get farmers' Fasal Bima Yojana, they can get insurance for their children's whatever small accidents, maybe accident insurance, that is. If all of them are clubbed together, and in order to deliver it at cost and at scale at his doorstep, you will be depending on data from various sources. And if there is a possibility of a breach at any source, at any place, then it would be necessary that all these acts, all these provisions, or all these data fiduciaries potentially are on the same page. So this would probably be the next stage. But once the Digital India Act comes, which would be kind of the mother act, which unfortunately should have come first, but I was asking the minister, they didn't have time, so maybe after the elections. But once that comes, actually that should be the umbrella, and every other law should be fitting in. But that's within the Ministry of IT. What we have to think about is the legislations which is coming from other ministries as well. For example, the Consumer Protection Act rules, there are, I think, 8 rules, including one e-commerce rule. Now that is being sponsored by the Ministry of Consumer Affairs. We did call both the ministries together in the Committee on Subordinate Legislation, which looks at all rules that are framed by all departments, to find that it was just one round of file consultation and nothing else. So I just want to say that we have moved quite ahead. We have moved forward. We have moved really forward. We have put in, I think we should be happy about the fact that there is at least a law on personal data protection, because the Supreme Court judgment came in 2017, and 2018 Justice Sri Krishna gave the report. We've been struggling with it. So 2023, we passed the legislation. So we are one of the countries where we have this. So this is, I think, incredible, but then there's a lot of work to do. And for this, the consultation has to be continuous, which is something which I think to understand from the market what is required for the economy to grow, the innovation to grow, all simultaneously, and how hard is hard and how soft is soft. Right? So thank you so much, ladies and gentlemen, for inviting me to this event. It is great hearing Pawan, my senior from college in St. Stephen's. Dinesh, we have been there with, Deepak. Deepak, we have been, I'm so sorry. Deepak, we have been together for the last so many years, right from the time this legislation was being mooted. And it is not just in the space of personal data protection. In fact, it is, whether it's on online gaming, whether it is on cryptos, I think we have discussed that as well. It's a very exciting space, but the dangers and the potential risks are so much that we have to be aware of. And it's very difficult to grapple, considering the fact, as I said, that our digital adoption rate is one of the highest in the world, but there is still 25% digital illiteracy in India. So they are adopting without understanding what are the risks. If they don't understand, it comes on the data fiduciaries, the regulators, and the government. Thank you so much.